Welcome to the Block and Tackle Show, hosted by Karl Block. Karl is a partner in the law firm of Loeb & here in Los Angeles, California. He will be tackling some of the biggest issues in business today. Welcome to the show.
Should we shift to Smith versus Spizzirri?
Of course.
Okay, so why don't you tell us the background of that case?
The issue is the Federal Arbitration Act, and specifically Section 3 of the Federal Arbitration Act. And if a district court determines that a dispute should go to arbitration, and a party requests a stay of the district court proceedings, what's the district court to do under those circumstances? And the Supreme Court, in a unanimous opinion by Justice Sotomayor, said, in those circumstances, the court should stay its proceedings pursuant to Section 3 of the Administrative Procedures Act, that it can't dismiss the proceedings. And it relies on the text of Section 3 of the Administrative Procedures Act, as well as the structure of the law. And as I say, Justice Sotomayor writes for the unanimous court.
So, I mean, in a unanimous decision, which isn't the most common thing, it's clear that they were of like mind. My understanding from people who are involved in arbitrations is what really is at stake is if a court dismisses the action, then the dismissal can be appealed, which can significantly affect whether you can even start the arbitration, and whether or not, if you even go forward with the arbitration, whether it's all going to be thrown out. And so it seemed like there was a little bit of gamesmanship, perhaps, that was going on, where people thought, hey, I'll hedge my bets, because normally in an arbitration, you can't challenge the arbitrability until after the arbitrator's decision has been confirmed by a court. But again, that seems to be, it was a statutory interpretation case, right?
Very much a statutory interpretation case. It was interpreting Section 3 of the Federal Arbitration Act. The court has generally been very pro-arbitration under the Federal Arbitration Act. You find that in many cases. One of the more recent ones is Epic Systems versus Lewis. And here the Supreme Court continues that deference, and the Supreme Court does so by saying, federal court follows Section 3 of the Federal Arbitration Act. If there's a matter before you, you're supposed to stay the federal court proceedings while the arbitration continues. This is when there's a request for a stay pending the outcome of the arbitration.
Okay. And did the Ninth Circuit have a contrary ruling on this before it went up?
Yes. I mean, the Ninth Circuit took a different approach. I think what the Ninth Circuit said is, if it's going to go to arbitration, there's no reason that the federal judge can't dismiss the case. No reason why the federal court has to stay the case.
Understood. Although, again, there's an appellate right that sneaks in there in contravention of the statute. Okay, so let's talk about Starbucks versus McKinney. Almost a 9-0, almost.
What's involved here is the standard to be met for an injunction. And there's traditional factors that have to be met for an injunction. And it's a 4-part test that the Supreme Court has articulated. And the question here is, well, under the National Labor Relations Board, National Labor Relations Act, should it just be a simplified 2-step approach? In the Sixth Circuit, in a case involving Starbucks and an injunction against Starbucks for what it done against union organizing, used a simplified version of the test. And the Supreme Court said, no, the law of equity and remedies is clear. It's a 4-part test, including things like likelihood of prevailing on the merits, irreparable injury, balance of the equities. And the Supreme Court said, there's no reason to treat requests for injunction in this context differently than in any other context. Again, Justice Sotomayor wrote the opinion for the court.
Yeah, and my understanding is that Section 10J of the National Labor Relations Act doesn't articulate a 2-part test. It doesn't articulate, on any test other than just cause. And I guess the Sixth Circuit just went off on that and created its own test.
Well, And it wasn't just in this case. And I don't know that it, in practical terms, makes any difference between the two-part test and the four-part test for preliminary injunctions. I think what the Supreme Court was saying is we have a well-established test that we use throughout the law with regard to remedies, a four-part test, follow it here.
Understood. I mean, I think there are those who would say, well, wait, you do have to show probability of prevailing on the merits, which arguably is a different standard than, just cause. But I understand, I mean, equity is equity. I mean, I'm not sure how violent a deviation it was from, I don't know if it's called the Winters test, but the four factors for a standard injunction. But it did seem like they were concerned about that.
It wasn't a significant departure. And also the Sixth Circuit opinion was written by Judge Danny Boggs, who's one of the more conservative judges in the country. And in the end, if you parse it, the difference of the two-part test and the four-part test doesn't matter very much. Yet I think this case says the traditional test for an injunction, preliminary injunction, has to be met here as well.
Okay. Are there, this came up under the National Labor Relations Act. Are there other statutes off the top of your head, federal statutes, where they actually try to articulate a different standard, or is this very unique?
I can't think of any, but that doesn't mean it didn't occur. And once more, I think because it was so similar from a practical perspective, the four-part test, most people didn't pay much attention to it.
Okay. So this next case we're going to talk about, the Consumer Finance Protection Board versus Community Financial Services. As a non-constitutional scholar, when I read this case, I was somewhat in awe of the differences between the majority and the minority about how you interpret statutes. And I think you would obviously be one of a very select few people in this country who could actually divine how they look at things. And maybe you should talk about, the facts of the case, and then, how you get the analysis by Justice Thomas versus Justice Kagan.
The Dodd-Frank Act created the Consumer Financial Protection Bureau, and it's meant to adopt rules, bring administrative proceedings to safeguard consumers in a variety of ways. And it's funded in an unusual manner. Instead of annual appropriations by Congress, it's funded through the Federal Reserve and funded up to a capped level. And the particular case here involves a payday lending rule that the Consumer Financial Protection Bureau adopted, and the company being regulated brought a challenge to it. And the United States Court of Appeals for the Fifth Circuit said the CFPB is unconstitutional as a violation of separation of powers. It's unconstitutional because it's funded not by an annual congressional appropriation, but rather through the money from the Federal Reserve. The Fifth Circuit says the Constitution requires an annual congressional appropriation, which doesn't exist as this agency. What's breathtaking about it is if the Fifth Circuit had been affirmed, it would have declared the entire agency out of business. It would have declared it unconstitutional.
The majority clearly felt, hey, Congress decided this is how it's going to be funded. What's your beef? Do you think that the Fifth Circuit just misread the Constitution?
I think in this instance, historical practice is enormously helpful. That there have been, since the early days of the Republic, funding of agencies through other than an annual appropriation. The Customs Service, the Post Office, from early in American history, were funded not by annual appropriations, but through mechanisms like the money that they collected. I think that the Fifth Circuit, which tends to be one of the most conservative circuits in the country, wanted to make a broader point about how in order to have federal expenditures, they need to come from Congress on an annual basis. Problem is the Supreme Court disagreed and reversed that.
Okay. And so, and apparently, again, from a non-constitutional scholar's perspective, it seemed like looking at legislative history and practice, there's no uniform way that the majority and the minority typically look at that.
I think that's right. I think this is an instance where even Justice Thomas, the foremost originalist, is willing to say, I look at the historical practice, and things like this existed back in 1787. And so therefore we should allow them today. I think some of the other justices like Kagan are going to be much more functional about it and say there's good reasons to use this kind of finance system. And it's permissible in part because it's been done this way since early in American history.
Okay. I think that there are those who will say, I think there's those in the finance industry and who are very concerned that this bureau is still in existence and that there's all kinds of regulations and things that they're going to be able to do in the consumer finance business. And, maybe they'll take comfort that if there's there's a promulgation of a regulation that is based upon an ambiguous statute, Loper Bright might find something to them. But I think they're very, very concerned that this independent agency, continues to have viability, notwithstanding all the challenges to it.
Oh, I think you're right. This agency, the Consumer Financial Protection Bureau, has very much been a target of conservatives from the beginning. In fact, just a few years ago, the Supreme Court declared it unconstitutional for Congress to limit the removal of the head of the Consumer Financial Protection Bureau. The court said when you have a single person in charge of an agency, Congress has to have authority to order the removal. But I think that this is an agency that's very much under the fire of conservatives. And I could imagine early in the Trump administration, they're trying to take some action to eliminate this agency.
Well, okay, and that raises a question. That's an interesting point. Do you think Congress has the authority to say we don't want this agency anymore? We want to uncreate it?
Absolutely. Anything Congress does by statute, Congress can change by statute.
Okay.
Congress created the CFPB by statute. If Congress wants to abolish the CFPB, Congress can do that. There'd be nothing unconstitutional about Congress deciding to eliminate an agency or program. But that said, the president can't eliminate an agency created by act of Congress. The president can't refuse to spend money that a spending bill authorizes and appropriates. Doing that would violate separation of powers.
Okay. All right. So are there any other deeper lessons to be learned from the CFPB case?
It's interesting. We had talked about the major question doctrine cases in the prior two terms that limited agencies. We talked about corner post, where the court made it easier to sue agencies for a longer period of time. We talked about Loper Bright versus Raimondo, where the court overruled Chevron deference. We talked about SEC versus Jarkesy, where matters that had previously gone to administrative agencies now need to come to courts. That's a good, significant string of victories for those who want to challenge agency proceedings. And there's no victory for the agencies in that list. But the CFPB case is a win for the agency and a loss for the challenger. And that's significant, though I have to note the win for the agency is a pretty narrow win, just saying Congress can create alternative funding mechanisms. It doesn't have to be a yearly appropriation.
That makes sense. Okay. Well, this term, all of the terms of the Supreme Court can be interesting for any number of reasons. And I know that you are very passionate about a number of them and a number of the constitutional rights and how things go. And it would be great to have you back on, later on in the year when we see what they've done. And particularly if there are cases where there are more attacks to the administrative state. And if you have any thoughts about anything that is going to be in front of the court this term right now, that'd be great. And if not, love to have you on later.
In mid-November, the Supreme Court, just very recently, granted review in a case involving the Federal Communication Commission. And the United States Court of Appeals for the Fifth Circuit, in a 9-7 en banc decision, found that an unconstitutional delegation of power to the agency and an unconstitutional subdelegation from the FCC to those who it was trying to assist and regulate. This is enormously important. The Supreme Court last declared a federal law unconstitutional as an excessive delegation of power in 1935.
Oh, wow.
Dr. Poultry versus United States and Panama Refining versus United States. The fact that the Fifth Circuit declared unconstitutional as an impermissible delegation of power is significant in itself. The Fifth Circuit here found that the delegation to private entities was an impermissible delegation. So I think you have here the chance for the court to revive the non-delegation doctrine, or maybe do so in a more limited context when it involves delegations to private entities.
So, and I'll just say this, and I know our time is short here. Many programs of the federal government delegate to private agencies.
That's right.
Medicare being one of them, but there's many more.
This is a court that all the cases we began talking about has very much called into question deference to the administrative state. It's called into question the premises of administrative law. I think that if the court revives the non-delegation doctrine, that will very much outweigh and outshine all the other things they've done in the administrative state in the cases before the Supreme Court this term.
Okay. Well, listen, as I said, I know our time is short. Yeah. I think our viewers and listeners and a lot of people in the business community are going to really enjoy having heard your thoughts. And I really, really appreciate you coming on the Block and Tackle show. If anybody has any questions after this, you can email me at carl@blockandtackleshow.com. The and in Block and Tackle Show is not an ampersand, it's AND. If they end up being questions for Professor Chemerinsky, I'll forward them on, and otherwise I'll just respond. But we really appreciate your time at the show. And like I said, love to have you back on after the end of the next term.
I'd like that very much. Thank you for having me on.
Okay, thank you. Thanks for tuning in. If you want more info on the show, please visit blockandtackleshow.com. And you can also email me at carl@blockandtackleshow.com. Thanks for tuning in.